60 Central Bureau of Investigation. Establishment of CBI. The Central Bureau of Investigation, CBI, was set up in 1963 by a resolution of the Ministry of Home Affairs. Later, it was transferred to the Ministry of Personnel, and now it enjoys the status of an attached office. 1. The Special Police Establishment, which looked into vigilance cases, set up in 1941, was also merged with the CBI. The establishment of the CBI was recommended by the Santhonam Committee on Prevention of Corruption, 1962 to 1964. The CBI is not a statutory body. It derives its powers from the Delhi Special Police Establishment Act, 1946. The CBI is the main investigating agency of the central government. It plays an important role in the prevention of corruption and maintaining integrity in administration. It also provides assistance to the Central Vigilance Commission and Lokpal. There is a difference between the nature of cases investigated by the National Investigation Agency, NIA, and the CBI. The NIA has been constituted after the Mumbai terror attack in 2008 mainly for investigation of incidents of terrorist attacks, funding of terrorism, and other terror-related crime, whereas the CBI investigates crime of corruption, economic offences, and serious and organised crime other than terrorism. Motto, mission and vision of CBI. Motto, industry, impartiality and integrity. Mission, to uphold the Constitution of India and law of the land through in-depth investigation and successful prosecution of offences, to provide leadership and direction to police forces, and to act as the nodal agency for enhancing interstate and international cooperation in law enforcement. Vision, based on its motto, mission and the need to develop professionalism, transparency, adaptability to change and use of science and technology in its working, the CBI will focus on 1. Combating corruption in public life, curbing economic and violent crimes through meticulous investigation and prosecution. 2. Evolving effective systems and procedures for successful investigation and prosecution of cases in various law courts. 3. Helping fight cyber and high-technology crime. 4. Creating a healthy work environment that encourages team building, free communication, and mutual trust. 5. Supporting state police organizations and law enforcement agencies in national and international cooperation, particularly relating to inquiries and investigation of cases. 6. Playing a lead role in the war against national and transnational organized crime. 7. Upholding human rights, protecting the environment, arts, antiques and heritage of our civilization. 8. Developing a scientific temper, humanism and the spirit of inquiry and reform. 9. Striving for excellence and professionalism in all spheres of functioning so that the organization rises to high levels of endeavor and achievement. Organization of CBI. Originally, 1963, the CBI was set up with the following 6 divisions: I. Investigation and Anti-Corruption Division, Delhi Special Police Establishment; 2. Technical Division; 3. Crime Records and Statistics Division; 4. Research Division; V. Legal and General Division; 6. Administration Division. At present, 2019, the CBI has the following 7 divisions: 1. Anti-Corruption Division; 2. Economic Offences Division; 3. Special Crimes Division; 4. Policy and Coordination Division; 5. Administration Division; 6. Directorate of Prosecution; 7. Central Forensic Science Laboratory. Composition of CBI. The CBI is headed by a director. He is assisted by a special director or an additional director. Additionally, it has a number of joint directors, deputy inspector generals, superintendents of police, and all other usual ranks of police personnel. In total, it has about 5,000 staff members, about 125 forensic scientists, and about 250 law officers. The director of CBI as Inspector General of Police, Delhi Special Police Establishment, is responsible for the administration of the organization. With the enactment of CVC Act, 2003, the superintendents of Delhi Special Police Establishment vests with the central government save investigations of offences under the Prevention of Corruption Act, 1988, in which the superintendents vests with the Central Vigilance Commission. The director of CBI has been provided security of 2-year tenure in office by the CVC Act, 2003. The Lokpal and Lokayuktas Act, 2013, amended the Delhi Special Police Establishment Act, 1946, and made the following changes with respect to the composition of the CBI. 1. The central government shall appoint the director of CBI on the recommendation of a 3-member committee consisting of the Prime Minister as chairperson, the leader of opposition in the Lok Sabha, and the Chief Justice of India or judge of the Supreme Court nominated by him. 2. There shall be a directorate of prosecution headed by a director for conducting the prosecution of cases under the Lokpal and Lokayuktas Act, 2013. The director of prosecution shall be an officer not below the rank of Joint Secretary to the Government of India. He shall function under the overall supervision and control of the director of CBI. He shall be appointed by the central government on the recommendation of the Central Vigilance Commission. He shall hold office for a period of 2 years. 3. The central government shall appoint officers of the rank of SP and above in the CBI on the recommendation of a committee consisting of the Central Vigilance Commissioner as chairperson, the Vigilance Commissioners, the Secretary of the Home Ministry, and the Secretary of the Department of Personnel. Later, the Delhi Special Police Establishment Amendment Act 2014 made a change in the composition of the committee related to the appointment of the director of CBI. It states that where there is no recognized leader of opposition in the Lok Sabha, then the leader of the single largest opposition party in the Lok Sabha would be a member of that committee. Functions of CBI. The functions of CBI are: I. Investigating cases of corruption, bribery and misconduct of central government employees. 2. Investigating cases relating to infringement of fiscal and economic laws, that is, breach of laws concerning export and import control, customs and central excise, income tax, foreign exchange regulations and so on. However, such cases are taken up either in consultation with or at the request of the department concerned. 3. Investigating serious crimes, having national and international ramifications, committed by organized gangs of professional criminals. 4. Coordinating the activities of the anti-corruption agencies and the various state police forces, v. Taking up, on the request of a state government, any case of public importance for investigation. 6. Maintaining crime statistics and disseminating criminal information. The CBI is a multidisciplinary investigation agency of the Government of India and undertakes investigation of corruption related cases, economic offences and cases of conventional crime. It normally confines its activities in the anti-corruption field to offences committed by the employees of the central government and union territories and their public sector undertakings. It takes up investigation of conventional crimes like murder, kidnapping, rape etc., on reference from the state governments or when directed by the Supreme Court or High Courts. The CBI acts as the National Central Bureau of Interpol in India. The Interpol wing of the CBI coordinates requests for investigation-related activities originating from Indian law enforcement agencies and the member countries of the Interpol. Provision of prior permission. The CBI is required to obtain the prior approval of the central government before conducting any inquiry or investigation into an offence committed by officers of the rank of Joint Secretary and above in the central government and its authorities. However, on May 6, 2014, the Supreme Court held as invalid the legal provision that makes prior sanction mandatory for the Central Bureau of Investigation to conduct a probe against senior bureaucrats in corruption cases under the Prevention of Corruption Act. 2A Constitution bench held that Section 6A of the Delhi Special Police Establishment Act, which granted protection to Joint Secretary and above officers from facing even a preliminary inquiry by the CBI in corruption cases, was violative of Article 14. Welcoming the court order, CBI director said, "It is a landmark judgment that will empower the agency in the investigations into several cases pending due to the provision that has now been struck down by the Constitution bench. We had for long been of the view that inquiry against senior officials need not require any prior permission." Writing the judgment, the CJI said, "Corruption is an enemy of the nation, and tracking down a corrupt public servant, howsoever high he may be, and punishing such person is a necessary mandate under the PC Act, 1988. The status or position of a public servant does not qualify the person from exemption from equal treatment. The decision-making power does not segregate corrupt officers into two classes, as they are common crime doers, and have to be tracked down by the same process of inquiry and investigation." The bench said, Section 6A of the DSPE Act granting protection to one set of officers is directly destructive and runs counter to the object and reason of the PC Act, 1988. It also undermines the object of detecting and punishing high-level corruption. How can two public servants against whom there are allegations of corruption or graft or bribe-taking or criminal misconduct under the PC Act, 1988, be made to be treated differently because one happens to be a junior officer and the other a senior decision-maker? The provision in Section 6A impedes tracking down the corrupt senior bureaucrats, as without previous approval of the central government, the CBI cannot even hold preliminary inquiry, much less an investigation into the allegations. The protection under Section 6A has propensity of shielding the corrupt, the bench added. Observing that there could not be any protection to corrupt public servants, the bench said, the aim and object of investigation is ultimately to search for truth, and any law that impedes that object may not stand the test of Article 14. Breach of rule of law, in our opinion, amounts to negation of equality under Article 14. Section 6A fails in the context of these facets of Article 14. CBI versus State Police. The role of the Special Police Establishment, a division of CBI, is supplementary to that of the State Police Forces. Along with State Police Forces, the Special Police Establishment, SPE, enjoys the concurrent powers of investigation and prosecution for offences under the Delhi Police Establishment Act, 1946. However, to avoid duplication and overlapping of cases between these two agencies, the following administrative arrangements have been made. I, the SPE, shall take up such cases which are essentially and substantially concerned with the central government's affairs or employees, even if they also involve certain state government employees. 2. The State Police Force shall take up such cases which are substantially concerned with the state government's affairs or employees, even if they also involve certain central government employees. 3. The SPE shall also take up cases against employees of public undertakings or statutory bodies established and financed by the central government. CBI Academy. The CBI Academy is located at Ghaziabad, Uttar Pradesh, and started functioning in 1996. Earlier, training programs were being conducted at the CBI Training Centre, New Delhi. The vision of the CBI Academy is excellence in training in the fields of crime investigation, prosecution, and vigilance functioning, and its mission is to train the human resources of CBI, state police, and the vigilance organizations to become professional, industrious, impartial, upright, and dedicated to the service of the nation. The Academy is the focal point of training activities within the organization and is responsible for identification of suitable training programs, regulation of nominations of trainees, and preparation of the annual training calendar. Beside the CBI Academy at Ghaziabad, there are 3 regional training centers imparting training at regional levels at Kolkata, Mumbai, and Chennai. There are 2 kinds of training courses which are being conducted in the CBI Academy. I. Short-term in-service courses, for officers of the CBI, state police, central paramilitary forces, and central government undertakings. 2. Long-term basic courses, for directly recruited deputy superintendents of police, sub-inspectors, and constables of CBI. 3. Notes and references. 1. The CBI comes under the administrative control of the Department of Personnel and Training, DPT, of the Ministry of Personnel. 2. The Hindu, no sanction needed for CBI to probe bureaucrats, SC, May 7, 2014. 3. Annual Report 2012, Central Bureau of Investigation, Government of India, pp 92-93. 61 Lokpal and Lokayuktas. Global scenario. Modern democratic states are characterized by a welfare orientation. Hence, the government has come to play an important role in the socio-economic development of a nation. This has resulted in the expansion of bureaucracy and the multiplication of administrative process, which in turn increase the administrative power and discretion enjoyed by the civil servants at different levels of the government. The abuse of this power and discretion by civil servants opens up scope for harassment, malpractices, maladministration, and corruption. Such a situation gives rise to citizens' grievances against administration. 1. The success of democracy and the realization of socio-economic development depends on the extent to which the citizens' grievances are redressed. Therefore, the following institutional devices have been created in different parts of the world to deal with the redressal of these grievances. 1. The ombudsman system. 2. The administrative court system. 3. The procurator system. The earliest democratic institution created in the world for the redressal of citizens' grievance is the Scandinavian institution of ombudsman. Donald C. Rowett, an international authority on the ombudsman, calls it a uniquely appropriate institution for dealing with the average citizen's complaints about unfair administrative actions. The institution of ombudsman was first created in Sweden in 1809. Ombud is a Swedish term and refers to a person who acts as the representative or spokesman of another person. According to Donald C. Rowett, ombudsman refers to an officer appointed by the legislature to handle complaints against administrative and judicial action. The Swedish ombudsman deals with the citizens' grievances in the following matters. I. Abuse of administrative discretion, that is, misuse of official power and authority. 2. Maladministration, that is, inefficiency in achieving the targets. 3. Administrative corruption, that is, demanding bribery for doing things. 4. Nepotism, that is, supporting one's own kith and kin in matters like providing employment. V. Discourtesy, that is, misbehavior of various kinds. For instance, use of abusive language. The Swedish ombudsman is appointed by the parliament for a term of 4 years. He can be removed only by the parliament on ground of its loss of confidence in him. He submits his annual report to the parliament and hence is also known as parliamentary ombudsman. But he is independent of the parliament, legislature, as well as the executive and judiciary. The ombudsman is a constitutional authority and enjoys the powers to supervise the compliance of laws and regulations by the public officials and see that they discharge their duties properly. In other words, he keeps a watch over all public officials, civil, judicial and military, so that they function impartially, objectively and legally, that is, in accordance with the law. However, he has no power to reverse or quash a decision and has no direct control over administration or the courts. The ombudsman can act either on the basis of a complaint received from the citizen against unfair administrative action or suo moto, i.e. on his own initiative. He can prosecute any erring official including the judges. However, he himself cannot inflict any punishment. He only reports the matter to the higher authorities for taking the necessary corrective action. In sum, the characteristics of the Swedish institution of ombudsman are as follows. I. Independence of action from the executive. 2. Impartial and objective investigation of complaints. 3. Suo moto power to start investigations. 4. Uninterrupted access to all the files of administration. V. Right to report to the parliament as opposed to the executive. The institution of ombudsman is based on the doctrine of administrative accountability to legislature. 6. Wide publicity given to its working in press and other media. 7. Direct, simple, informal, cheap and speedy method of handling. Complaints from Sweden. The institution of ombudsman spread to other Scandinavian countries. Finland, 1919, Denmark, 1955, and Norway, 1962. New Zealand is the first Commonwealth country in the world to have adopted the ombudsman system in the form of a parliamentary commissioner for investigation in 1962. The United Kingdom adopted ombudsman-like institution called parliamentary commissioner for administration in 1967. Since then, more than 40 countries of the world have adopted ombudsman-like institutions with different nomenclature and functions. The ombudsman in India is called Lokpal or Lokayukta. Donald C. Rowett says that the institution of ombudsman is a bulwark of democratic government against the tyranny of officialdom. While Gerald E. Caden described the ombudsman as institutionalized public conscience. Another unique institutional device created for the redressal of citizens' grievances against administrative authorities is the French system of administrative courts. Due to its success in France, the system has gradually spread to many other European and African countries like Belgium, Greece and Turkey. The socialist countries like the former USSR, now Russia, China, Poland, Hungary, Czechoslovakia, and Romania have created their own institutional device for the redressal of citizens' grievances. It is called procurator system in these countries. It should be noted here that the office of the Procurator General is still functioning in Russia. He is appointed for a tenure of 7 years. Position in India. The existing legal and institutional framework to check corruption and redress citizens' grievances in India consists of the following. 1. Public Servants, Enquiries, Act, 1852. Indian Penal Code, 1863. Special Police Establishment, 1941-4. Delhi Police Establishment Act, 1946-5. Prevention of Corruption Act, 1988-6. Commissions of Inquiry Act, 1952, Against Political Leaders and Eminent Public Men, 7. All India Services, Conduct Rules, 1968-8. Central Civil Services, Conduct Rules, 1964-9. Railway Services, Conduct Rules, 1966-10. Vigilance Organizations in Ministries or Departments, Attached and Subordinate Officers, and Public Undertakings 11. Central Bureau of Investigation, 1963-12. Central Vigilance Commission, 1964-13. State Vigilance Commissions, 1964-14. Anti-Corruption Bureaus in States 15. Lokpal, Ombudsman, at the Centre 16. Lokayukta, Ombudsman, in State 17. Divisional Vigilance Board 18. District Vigilance Officer. 19. National Consumer Disputes Redressal Commission. 20. National Commission for SCS 21. National Commission for SDS 22. Supreme Court and High Courts in States 23. Administrative Tribunals, Quasi-Judicial Bodies, 24. Directorate of Public Grievances in the Cabinet Secretariat, 1988-25. Parliament and its Committees 26. File-to-Field Program in some states like Kerala. In this innovative scheme, the administrator goes to the village area and hears public grievances and takes immediate action wherever possible. Lokpal. The Administrative Reforms Commission, ARC, of India, 1966 to 1970, recommended the setting up of 2 special authorities designated as Lokpal and Lokayukta for the redressal of citizens' grievances too. These institutions were to be set up on the pattern of the institution of Ombudsman in Scandinavian countries and the Parliamentary Commissioner for Investigation in New Zealand. The Lokpal would deal with complaints against ministers and secretaries at central and state levels, and the Lokayukta, one at the centre and one in every state, would deal with complaints against other specified high officials. The ARC kept the judiciary outside the purview of Lokpal and Lokayukta, as in New Zealand. But in Sweden the judiciary is within the purview of Ombudsman. According to the ARC, the Lokpal would be appointed by the President after consultation with the Chief Justice of India, the Speaker of Lok Sabha, and the Chairman of the Rajya Sabha. The ARC also recommended that the institutions of Lokpal and Lokayukta should have the following features. 1. They should be demonstratively independent and impartial. 2. Their investigations and proceedings should be conducted in private and should be informal in character. 3. Their appointment should be, as far as possible, non-political. 4. Their status should compare with the highest judicial functionaries in the country. 5. They should deal with matters in the discretionary field involving acts of injustice, corruption or favoritism. 6. Their proceedings should not be subject to judicial interference. 7. They should have the maximum latitude and powers in obtaining information relevant to their duties. 8. They should not look forward to any benefit or pecuniary advantage from the executive government. The government of India accepted the recommendations of ARC in this regard. So far, 10 official attempts have been made to bring about legislation on this subject. Bills were introduced in the Parliament in the following years. 1. In May 1968, by the Congress government headed by Indira Gandhi. 2. In April 1971, again by the Congress government headed by Indira Gandhi. 3. In July 1977, by the Janata government headed by Morarji Desai. 4. In August 1985, by the Congress government headed by Rajiv Gandhi. 5. In December 1989, by the National Front government headed by VP Singh. 6. In September 1996, by the United Front government headed by Deve Gowda. 7. In August 1998, by the BJP-led coalition government headed by AB Vajpayee. 8. In August 2001, by the NDA government headed by AB Vajpayee. 9. In August 2011, by the UPA government headed by Manmohan Singh. 10. In December 2011, by the UPA government headed by Manmohan Singh. The first 4 bills lapsed due to the dissolution of Lok Sabha, while the 5th one was withdrawn by the government. The 6th and 7th bills also lapsed due to the dissolution of the 11th and 12th Lok Sabha. Again, the 8th bill, 2001, lapsed due to the dissolution of the 13th Lok Sabha in 2004. The 9th bill, 2011, was withdrawn by the government. Lokpal and Lokayuktas Act, 2013. Features. The salient features of the Lokpal and Lokayuktas Act, 2013, are as follows. Point 31. It seeks to establish the institution of the Lokpal at the centre and the Lokayukta at the level of the state, and thus seeks to provide a uniform vigilance and anti-corruption roadmap for the nation both at the centre and at the states. The jurisdiction of Lokpal includes the Prime Minister, Ministers, Members of Parliament and Groups A, B, C and D officers, and officials of the central government. 2. The Lokpal to consist of a chairperson with a maximum of 8 members, of which 50% shall be judicial members. 3. 50% of the members of the Lokpal shall come from amongst the SCS, the SDS, the OBCs, minorities and women. 4. The selection of the chairperson and the members of Lokpal shall be through a selection committee consisting of the Prime Minister, the Speaker of the Lok Sabha, the Leader of the Opposition in the Lok Sabha, the Chief Justice of India or a sitting Supreme Court judge nominated by the Chief Justice of India and an eminent jurist to be nominated by the President of India on the basis of recommendations of the first 4 members of the selection committee. 5. A search committee will assist the selection committee in the process of selection. 50% of the members of the search committee shall also be from amongst the SCS, the SDS, the OBCs, minorities and women. 6. The Prime Minister has been brought under the purview of the Lokpal with subject matter exclusions and specific process for handling complaints against the Prime Minister. 7. Lokpal's jurisdiction will cover all categories of public servants, including Group A, Group B, Group C, and Group D officers and employees of government. On complaints referred to the CVC by the Lokpal, the CVC will send its report of preliminary inquiry in respect of Group A and Group B officers back to the Lokpal for further decision. With respect to categories of employees from Group C and Group D, the CVC will proceed further in exercise of its own powers under the CVC Act subject to reporting and review by the Lokpal. 8. The Lokpal will have the power of superintendence and direction over any investigating agency, including the CBI, for cases referred to them by the Lokpal. 9. A high-powered committee chaired by the Prime Minister will recommend the selection of the Director of CBI. 10. It incorporates provisions for attachment and confiscation of property of public servants acquired by corrupt means, even while the prosecution is pending. 11. It lays down clear timelines. For preliminary inquiry, it is 3 months extendable by 3 months. For investigation, it is 6 months, which may be extended by 6 months at a time. For trial, it is 1 year extendable by 1 year, and to achieve this, special courts to be set up. 12. It enhances maximum punishment under the Prevention of Corruption Act from 7 years to 10 years. The minimum punishment under Section 7, 8, 9 and 12 of the Prevention of Corruption Act will now be 3 years, and the minimum punishment under Section 15, punishment for attempt, will now be 2 years. 13. Institutions which are financed fully or partly by government are under the jurisdiction of Lokpal, but institutions aided by government are excluded. 14. It provides adequate protection for honest and upright public servants. 15. Lokpal conferred with power to grant sanction for prosecution of public servants in place of the government or competent authority. 16. It contains a number of provisions aimed at strengthening the CBI such as setting up of a Directorate of Prosecution headed by a Director of Prosecution under the overall control of the Director of CBI. 2. Appointment of the Director of Prosecution on recommendation of the CVC. 3. Maintenance of a panel of advocates by CBI other government advocates with the consent of the Lokpal handling Lokpal referred cases. 4. Transfer of officers of CBI investigating cases referred by Lok with the approval of Lokpal. V. Provision of adequate funds to CBI for investigating cases referred by Lokpal. 17. All entities receiving donations from foreign source in the context of the Foreign Contribution Regulation Act (FCIA) in excess of 10 Indian rupees lakhs per year are brought under the jurisdiction of Lokpal. 18. It contains a mandate for setting up of the institution of Lokayukta through enactment of a law by the state legislature within a period of 365 days from the date of commencement of this act. Thus, the act provides freedom to the states to decide upon the contours of the Lokayukta mechanism in their respective states. Drawbacks. The following are the drawbacks, shortcomings, of the Lokpal and Lokayuktas Act 20133A. 1. Lokpal cannot suo motu proceed against any public servant. 2. Emphasis on form of complaint rather than substance. 3. Heavy punishment for false and frivolous complaints against public servants may deter complaints being filed to Lokpal. 4. Anonymous complaints not allowed. Can't just make a complaint on plain paper and drop it in a box with supporting documents. 5. Legal assistance to public servant against whom complaint is filed. 6. Limitation period of 7 years to file complaints. 7. Very non-transparent procedure for dealing with complaints against the PM. Lokayuktas. Even much before the enactment of the Lokpal and Lokayuktas Act 2013 itself, many states had already set up the institution of Lokayuktas. It must be noted here that the institution of Lokayukta was established first in Maharashtra in 1971. Although Odisha had passed the act in this regard in 1970, it came into force only in 1983. Till 2013, 21 states and 1 union territory, Delhi, have established the institution of Lokayuktas. The details in this regard are mentioned below in Table 61.1. Table 61.1 Establishment of Lokayukta in states, chronological order, SL. No. States of created in, enacted in, 1. Odisha 1972. Maharashtra 1971-3. Rajasthan. The various aspects of the institution of Lokayukta are structural variations. The structure of the Lokayukta is not same in all the states. Some states like Rajasthan, Karnataka, Andhra Pradesh and Maharashtra have created the Lokayukta, as well as Upalokayukta, while some others like Bihar, Uttar Pradesh and Himachal Pradesh have created only the Lokayukta. There are still other states like Punjab and Orissa that have designated officials as Lokpal. This pattern was not suggested by the ARC in the states. Appointment. The Lokayukta and Upalokayukta are appointed by the governor of the state. While appointing, the governor in most of the states consults a. the Chief Justice of the State High Court, and b. the Leader of Opposition in the State Legislative Assembly. 4. Qualifications. Judicial qualifications are prescribed for the Lokayukta in the states of Uttar Pradesh, Himachal Pradesh, Andhra Pradesh, Gujarat, Orissa, Karnataka and Assam. But no specific qualifications are prescribed in the states of Bihar, Maharashtra and Rajasthan. Tenure. In most of the states, the term of office fixed for Lokayukta is of 5 years duration or 65 years of age, whichever is earlier. He is not eligible for reappointment for a second term. Jurisdiction. There is no uniformity regarding the jurisdiction of Lokayukta in all the states. The following points can be noted in this regard. A. The Chief Minister is included within the jurisdiction of Lokayukta in the states of Himachal Pradesh, Andhra Pradesh, Madhya Pradesh and Gujarat, while he is excluded from the purview of Lokayukta in the states of Maharashtra, Uttar Pradesh, Rajasthan, Bihar and Orissa. B. Ministers and higher civil servants are included in the purview of Lokayukta in almost all the states. Maharashtra has also included former ministers and civil servants. C. Members of state legislatures are included in the purview of Lokayukta in the states of Andhra Pradesh, Himachal Pradesh, Gujarat, Uttar Pradesh and Assam. D. The authorities of the local bodies, corporations, companies and societies are included in the jurisdiction of the Lokayukta in most of the states. Investigations. In most of the states, the Lokayukta can initiate investigations either on the basis of a complaint received from the citizen against unfair administrative action or suo moto. But he does not enjoy the power to start investigations on his own initiative, suo moto, in the states of Uttar Pradesh, Himachal Pradesh and Assam. Scope of cases covered. The Lokayukta can consider the cases of grievances as well as allegations in the states of Maharashtra, Uttar Pradesh, Assam, Bihar and Karnataka. But in Himachal Pradesh, Andhra Pradesh, Rajasthan and Gujarat, the job of Lokayuktas is confined to investigating allegations, corruption, and not grievances, maladministration. Other features. 1. The Lokayukta presents, annually, to the governor of the state a consolidated report on his performance. The governor places this report along with an explanatory memorandum before the state legislature. The Lokayukta is responsible to the state legislature. 2. He takes the help of the state investigating agencies for conducting inquiries. 3. He can call for relevant files and documents from the state government departments. 4. The recommendations made by the Lokayukta are only advisory and not binding on the state government. Notes and references. 1. According to the Chamber's dictionary, grievance means a ground of complaint, a condition felt to be oppressive or wrongful. 2. The ARC headed by Moraji Desai submitted a special interim report on the problems of redressal of citizens' grievances in 1966. 3. Press Information Bureau, Government of India, December 23, 2013. 3a. Tixman's Guide to Lokpal and Lokayuktas, Act 2013, pp. I9 to I11. 3b. In Jammu and Kashmir, the institution is known as State Accountability Commission, SAC. 4. But, in Andhra Pradesh, the leader of the opposition in the State Legislative Assembly is not required to be consulted in this regard. In Karnataka, on the other hand, the chairman of the State Legislative Council, the Speaker of the State Legislative Assembly and the leader of opposition in the State Legislative Council are also required to be consulted on this matter. 62. National Investigation Agency. Establishment of the NIA. The National Investigation Agency, NIA, was constituted in 2009 under the provisions of the National Investigation Agency Act, 2008, NIA Act. It is the central counterterrorism law enforcement agency in the country. The NIA was established in the backdrop of the 2008 Mumbai terror attacks, popularly known as the 26/11 incident. This national horror led to the realization of the need for a separate federal agency to deal with terror-related crimes in the country. The headquarters of the NIA is at New Delhi. The branch offices of the NIA are located at Hyderabad, Guwahati, Mumbai, Lucknow, Kochi, Kolkata, Jammu and Raipur. In addition, the NIA has a separate specialized cell known as TFFC cell dealing with the subjects of fake currency notes and terror funding. The NIA is headed by a Director General. He is appointed by the central government. His powers are similar to the powers exercisable by a Director General of Police in respect of the police force in a state. The NIA works under the administrative control of the Ministry of Home Affairs, Government of India. The state government extends all assistance and cooperation to the NIA for investigation of the offences specified under the NIA Act. Rationale of the NIA. While introducing the NIA bill in the Parliament, the Government of India gave the following reasons for creating the NIA. 1. Over the past several years, India has been the victim of large-scale terrorism sponsored from across the borders. There have been innumerable incidents of terrorist attacks, not only in the militancy and insurgency-affected areas and areas affected by left-wing extremism, but also in the form of terrorist attacks and bomb blasts, etc., in various parts of the hinterland and major cities, etc. 2. A large number of such incidents are found to have complex interstate and international linkages, and possible connection with other activities like the smuggling of arms and drugs, pushing in and circulation of fake Indian currency, infiltration from across the borders, etc. 3. Keeping all these in view, it was felt that there was a need for setting up of an agency at the central level for the investigation of offences related to terrorism and certain other acts which have national ramifications. 4. Several expert committees and the Second Administrative Reforms Commission, 2, have also made recommendations for establishing such an agency. 5. The government, after due consideration and examination of the issues involved, proposed to enact a legislation to make provisions for establishment of an NIA in a concurrent jurisdiction framework, with provisions for taking up specific cases under specific acts for investigation. These provisions are proposed to be incorporated in the National Investigation Agency Bill, 2008. Functions of the NIA. The NIA is mandated to investigate and prosecute offences under the various acts mentioned in the schedule of the NIA Act. In pursuance of its mandate, the NIA collates and analyses counterterrorism investigation. It also shares inputs with its sister intelligence agencies and law enforcement units both at central and state governments level. In more detail, the functions assigned to the NIA are as follows. 3. A. To investigate and prosecute offences in respect of the acts specified in the schedule of the NIA Act. B. To provide assistance to, and seek assistance from, other intelligence and investigation agencies of the central government and state governments. C. To take other such measures which may be necessary for speedy and effective implementation of the provisions of the NIA Act. Vision of the NIA. The following points highlight the vision of the NIA. 1. The NIA aims to be a thoroughly professional investigative agency matching the best international standards. 2. The NIA aims to set the standards of excellence in counter-terrorism and other national security-related investigations at the national level by developing into a highly trained, partnership-oriented workforce. 3. The NIA aims at creating deterrents for existing and potential terrorist groups or individuals. 4. The NIA aims to develop as a storehouse of all terrorist-related information. Mission of the NIA. The mission of the NIA is as follows. 1. In-depth professional investigation of scheduled offences using the latest scientific methods of investigation and setting up such standards as to ensure that all cases entrusted to the NIA are detected. 2. Ensuring effective and speedy trial. 3. Developing into a thoroughly professional, result-oriented organisation, upholding the Constitution of India and laws of the land, giving prime importance to the protection of human rights and dignity of the individual. 4. Developing a professional workforce through regular training and exposure to the best practices and procedures. 5. Displaying scientific temper and progressive spirit while discharging the duties assigned. 6. Inducting modern methods and latest technology in every sphere of activities of the agency. 7. Maintaining professional and cordial relations with the governments of states and union territories and other law enforcement agencies in compliance with the legal provisions of the NIA Act. 8. Assisting all states and other investigating agencies in investigation of terrorist cases. 9. Building a database on all terrorist-related information and sharing the available database with the states and other agencies. 10. Studying and analysing laws relating to terrorism in other countries and regularly evaluating the adequacy of existing laws in India and proposing changes, as and when necessary. 11. Winning the confidence of the citizens of India through selfless and fearless endeavours. Jurisdiction of the NIA. The NIA has concurrent jurisdiction to investigate and prosecute the offences affecting the sovereignty, security and integrity of India, security of state, friendly relations with foreign states and offences under various acts enacted to implement international treaties, agreements, conventions and resolutions of the UNO, its agencies and other international organisations. The NIA is empowered to probe terror attacks including bomb blasts, hijacking of aircrafts and ships, attacks on nuclear installations and use of weapons of mass destruction. In 2019, the jurisdiction of the NIA was extended for. Consequently, the NIA is also empowered to probe the offences relating to human trafficking, counterfeit currency or banknotes, manufacture or sale of prohibited arms, cyberterrorism and explosive substances. NIA Amendment Act 2019. The various features or provisions of the amendment are as follows. 5. 1. It applied the provisions of the NIA Act also to persons who commit a scheduled offence beyond India against Indian citizens or affecting the interest of India. 2. It provided that the officers of the NIA shall have the similar powers, duties, privileges and liabilities being exercised by the police officers in connection with the investigation of offences, not only in India, but also outside India. 3. It empowered the central government, with respect to a scheduled offence committed outside India, to direct the NIA to register the case and take up investigation, as if such offence has taken place in India. 4. It provided that the central government and the state governments may designate sessions courts as special courts for conducting the trial of offences under the NIA Act. 5. It inserted certain new offences in the schedule of the NIA Act 6. Notes and references. 1. Based on the statement of objects and reasons appended to the NIA Bill, 2008. 2. The Second Administrative Reforms Commission, Chairman, Veerappa Moily, 2005-09, in its report entitled Combating Terrorism, 2008. 3. The National Investigation Agency, Manner of Constitution, Rules, 2008. 4. Vide the NIA Amendment, Act 2019. 5. Based on the statement of objects and reasons appended to the NIA Amendment, Bill, 2019. 6. See the last paragraph under the above heading, Jurisdiction of the NIA. 63. National Disaster Management Authority. Establishment of the NDMA. The Government of India, recognising the importance of disaster management as a national priority, had set up a high-powered committee in 1999 and a national committee in 2001 after the Gujarat earthquake to make recommendations on the preparation of disaster management plans and suggest effective mitigation mechanisms. However, after the Indian Ocean tsunami of 2004, the Government of India took a defining step in the legislative history of the country by enacting the Disaster Management Act, 20051. The Act provided for the creation of the National Disaster Management Authority, NDMA, to spearhead and implement a holistic and integrated approach to disaster management in the country. Initially, the NDMA was constituted in 2005 by an executive order of the Government of India. Subsequently, the NDMA was notified in 2006 under the provisions of the Act 2. The NDMA consists of a chairperson and other members not exceeding 9. The Prime Minister is the ex officio chairperson of the NDMA. The other members are nominated by the chairperson of the NDMA. The chairperson of the NDMA designates one of the members as the vice chairperson of the NDMA. The vice chairperson has the status of a cabinet minister, while the other members have the status of a minister of state. The NDMA is the apex body for disaster management in the country. It works under the administrative control of the Union Ministry of Home Affairs. The NDMA was established with this vision, to build a safer and disaster-resilient India by a holistic, proactive, technology-driven and sustainable development strategy that involves all stakeholders and fosters a culture of prevention, preparedness and mitigation. Objectives of the NDMA. The objectives of the NDMA are as follows. 1. To promote a culture of prevention, preparedness and resilience at all levels through knowledge, innovation and education. 2. To encourage mitigation measures based on technology, traditional wisdom and environmental sustainability. 3. To mainstream disaster management into the developmental planning process. 4. To establish institutional and techno-legal frameworks to create an enabling regulatory environment and a compliance regime. 5. To ensure efficient mechanism for identification, assessment and monitoring of disaster risks. 6. To develop contemporary forecasting and early warning systems backed by responsive and fail-safe communication with information technology support. 7. To ensure efficient response and relief with a caring approach towards the needs of the vulnerable sections of the society. 8. To undertake reconstruction as an opportunity to build disaster-resilient structures and habitat for ensuring safer living. 9. To promote a productive and proactive partnership with the media for disaster management. Functions of the NDMA. The NDMA has the responsibility for laying down the policies, plans and guidelines for disaster management for ensuring timely and effective response to disaster. The functions of the NDMA are as follows. 1. To lay down policies on disaster management. 2. To approve the national plan. 3. To approve plans prepared by the ministries or departments of the Government of India in accordance with the national plan. 4. To lay down guidelines to be followed by the state disaster management authorities, SDMAs, 3. In drawing up the state plan. 5. To lay down guidelines to be followed by the different ministries or departments of the Government of India for the purpose of integrating the measures for prevention of disaster or the mitigation of its effects in their development plans and projects. 6. To coordinate the enforcement and implementation of the policy and plan for disaster management. 7. To recommend provision of funds for the purpose of mitigation. 8. To provide such support to other countries affected by major disasters as may be determined by the central government. 9. To take other such measures for the prevention of disaster, or the mitigation, or preparedness and capacity building for dealing with the threatening disaster situation, or disaster, as it may consider necessary. 10. To lay down broad policies and guidelines for the functioning of the National Institute of Disaster Management. 4. Additional functions of the NDMA. In addition to the above, the NDMA also performs the following functions. 1. It recommends guidelines for the minimum standards of relief to be provided to persons affected by disaster. 2. It recommends, in cases of disasters of severe magnitude, relief and repayment of loans or grant of fresh loans on concessional terms to the persons affected by such disasters. 3. It exercises the general superintendence, direction and control of the National Disaster Response Force, NDIF. This force has been constituted for the purpose of specialist response to a threatening disaster situation or disaster. 4. It authorizes the concerned department or authority to make the emergency procurement of provisions or materials for rescue or relief in any threatening disaster situation or disaster. In such case, the standard procedure requiring inviting of tenders is deemed to be waived. 5. It prepares an annual report on its activities and submits it to the central government. The central government causes it to be laid before both houses of Parliament. 5. State Disaster Management Authority. Composition. Every state government should establish a State Disaster Management Authority, SDMA, for the state. An SDMA consists of a chairperson and other members, not exceeding 9. The Chief Minister of the state is the ex officio chairperson of the SDMA. The chairperson of the State Executive Committee is the ex officio member of the SDMA. The other members, not exceeding 8, are nominated by the chairperson of the SDMA. The chairperson of the SDMA designates one of the members as the vice chairperson of the SDMA. The chairperson of the State Executive Committee acts as the ex officio chief executive officer of the SDMA. Functions. An SDMA has the responsibility for laying down policies and plans for disaster management in the state. Its functions include the following. 1. To lay down the state disaster management policy. 2. To approve the state plan in accordance with the guidelines laid down by the NDMA. 3. To approve the disaster management plans prepared by the departments of the government of the state. 4. To lay down guidelines to be followed by the departments of the government of the state for the purposes of integration of measures for prevention of disasters and mitigation in the development plans and projects and provide necessary technical assistance thereof. 5. To coordinate the implementation of the state plan. 6. To recommend provision of funds for mitigation and preparedness measures. 7. To review the development plans of the different departments of the state and ensure that prevention and mitigation measures are integrated therein. 8. To review the measures being taken for mitigation, capacity building and preparedness by the departments of the government of the state and issue such guidelines as may be necessary. District Disaster Management Authority. Composition. Every state government should establish a District Disaster Management Authority, DDMA, for every district in the state. A DDMA consists of a chairperson and other members, not exceeding 7. The collector, or district magistrate or deputy commissioner, of the district is the ex officio chairperson of the DDMA. The elected representative of the local authority is the ex officio co-chairperson of the DDMA. But in case of tribal areas, as referred to in the 6th schedule to the Constitution of India, the chief executive member of the District Council of Autonomous District is the ex officio co-chairperson of the DDMA. The chief executive officer of the DDMA, the superintendent of police and the chief medical officer of the district are the ex officio members of the DDMA. Not more than 2 other district level officers are appointed by the state government as the members of the DDMA. In case of a district where Zilla Parishad exists, the chairperson of that Zilla Parishad is the co-chairperson of the DDMA. The chief executive officer of the DDMA is appointed by the state government. Functions. The DDMA acts as the district planning, coordinating and implementing body for disaster management and takes all measures for the purposes of disaster management in the district in accordance with the guidelines laid down by the NDMA and the SDMA. Its functions are as follows. 1. To prepare a disaster management plan including district response plan for the district. 2. To coordinate and monitor the implementation of the national policy, national plan, state plan and district plan. 3. To ensure that the areas in the district vulnerable to disasters are identified and measures for the prevention of disasters and the mitigation of its effects are undertaken by the departments of the government at the district level as well as by the local authorities. 4. To ensure that the guidelines for prevention of disasters, mitigation of its effects, preparedness and response measures, as laid down by the NDMA and the SDMA are followed by all departments of the government at the district level and the local authorities in the district. 5. To organize and coordinate specialized training programs for different levels of officers, employees and voluntary rescue workers in the district. 6. To facilitate community training and awareness programs for prevention of disaster or mitigation with the support of local authorities, governmental and non-governmental organizations. 7. To set up, maintain, review and upgrade the mechanism for early warnings and dissemination of proper information to the public. 8. To advise, assist and coordinate the activities of the departments of the government at the district level, statutory bodies and other governmental and non-governmental organizations in the district engaged in disaster management. 9. To identify buildings and places which could, in the event of any threatening disaster situation or disaster, be used as relief centers or camps and make arrangements for water supply and sanitation in such buildings or places. 10. To perform such other functions as the state government or SDMA may assign to it or as it deems necessary for disaster management in the district. Notes and references. 1. Annual Report 2016-17, National Disaster Management Authority, Government of India, page 2. 2. IBID. 3. The Act also provided for the establishment of the State Disaster Management Authorities and the District Disaster Management Authorities. 4. The National Institute of Disaster Management is located at New Delhi. 5. The Disaster Management Annual Report of National Authority Rules 2006. Part IX. Other constitutional dimensions. 64. Cooperative society.